And Glenn, of course, we always start with whoever was in the courtroom, and that's you. So how hot was that hot bench? Because when I was listening, we just had the audio, I felt I could hear the judges coming out of their chairs and leaning forward and trying to wrestle the Trump lawyer into actually working with at least one of their hypotheticals.
Yeah, Lawrence, I fought the urge to sort of loosen my tie, unbutton my collar, and yell out to John Sauer, Donald Trump's lawyer, for gosh sakes, man, just answer the hypothetical. You know, I may not have been in as many appellate arguments as my friend Neil, but I've argued before that bench and other appellate courts. And, you know, when judges present a hypothetical, they expect an answer, even if it's an answer that is perhaps unduly favorable to your client's position. But, you know, John Sauer steadfastly refused to answer Judge Millett's hypotheticals, and she let him know that she was really displeased about it, and I don't think it served his client well. What he kept doing, Lawrence, was just saying the following phrase as if it were a magical incantation. He said, everything Donald Trump does and says and posts is core political speech. Therefore, there can be no prior restraint. There can be no gag order limiting his core political speech. And, you know, both Judge Millett and Judge Garcia very pointedly said there is a clear pattern that has been established. Donald Trump issues statements, including about witnesses, and witnesses get threatened. So they were having none of this sort of absolute argument that Donald Trump's lawyer was making. And even though as the argument progressed for, as you say, 2 hours and 20 minutes, they also had some very pointed questions of the prosecutor on Jack Smith's team. But it seems pretty clear that they're going to be inclined to perhaps narrow the gag order somewhat, hand it back to the trial court judge, Judge Tanya Chutkan, and perhaps instruct her to, you know, impose something that is a little bit more narrow than what she imposed in the first instance.
Neil, with all your practice in front of that appeals court, I'm just wondering what you were thinking at minute 21, minute 22, when we were still on the first judge's questions. Like, no other judges had even gotten to speak at that point.
So first of all, Lawrence, this is our nation's second highest court, the D.C. Circuit. They're reviewing a judgment by Judge Tanya Chutkan, a very, very well-respected judge in D.C. Yes, the argument was set for 20 minutes per side, as you started saying at the beginning of the show, but it is not uncommon for this court, and Judge Millett in particular, to go, last time I argued before her was 3 hours long. And she is an extraordinary, the whole panel, this is an extraordinary group of judges. They're really dug in on every case, not just this case. And it's actually a real privilege that the American, or it's actually, I think the American public's right to hear this argument. And so it was great that we could all hear it live. What did I think at minute 20? It's the same thing I thought at minute 2, which is, hey, Mr. Trump's lawyer, answer the question. Yeah. Answer the question. She spent 20 minutes trying to get an answer to the most simple questions. He couldn't answer them. So, I mean, Trump's lawyer basically took this kind of, you know, go home or go big approach, and I think he's going home, basically, at the end of this. You know, I do think that the government got some hard questions, Jack Smith's team, toward the end. They weren't questions really that Donald Trump's lawyer had focused on, but ones that they in their own research did. And in particular, I think they were concerned, did Judge Chutkan's gag order basically reach too far? Did it say, for example, Donald Trump can't criticize the prosecutor, Jack Smith, in a presidential debate or something like that? That, the panel was saying, the First Amendment protects. So I think we may expect some modest trimming of the gag order, but at the end of the day, it sure sounded to me like the gag order will be upheld and history will be made. For the first time, a former president will be gagged by the nation's second highest court, and the person to blame for that is none other than a guy named Donald Trump who keeps opening his mouth, threatening witnesses, threatening the prosecutors, threatening others involved with this, and ultimately undermining a fair trial.
And of course, Andrew, we had no set of precedents really to present to this court today. That's why they kept asking these hypotheticals, is because they have to carve out something here that isn't sitting there ready to go as a doctrine to use in this case. And you just had the feeling that the Trump lawyer was just never going to admit a thing. For what? So that the next stage, appealing to the Supreme Court, he hasn't conceded anything? What is that about?
Yeah, so that's one of the reasons to do it, is if you think you're going to lose in this proceeding, essentially stonewall here, so that there's no concession that can be latched onto. But to give you an example of what Neil's talking about in terms of the question that the court had that was really legitimate was to say, look, it's a given that every defendant, when they're released, is told, do not commit a crime. That includes do not threaten a witness. That's not a gag order. That's just you can't commit a crime while out on bail. And so their question to him was, well, what else can the judge do? Does the judge have to wait until the crime is committed, or is there any prophylactic step that she can take given this record? And as Neil said, this was repeated conduct where he knew he did a call, there was a response, call, response, over and over again. And he would not answer that question. And there's a reason, is that he would be conceding ground to say, yes, the First Amendment does take sort of a second place to that balancing that should occur. And that's where the court is clearly going to say that the judge is entitled to do some prophylactic step to make sure someone doesn't get hurt. The main issue is going to be sort of just, do they think it's as far as Judge Chutkan went, or is it curtailed somewhat to cover witnesses and jurors, but maybe less protection for Jack Smith and his staff or the court and its staff?
So I think Andrew just got it exactly right. The key question, and you showed it in your interchange with Judge Garcia, the youngest judge on this panel, is he said, look, do you have to wait? Does the judge have to wait until someone gets killed or hurt in order for a gag order to exist? And he asked that question multiple different ways to the Trump lawyer. Trump lawyer never answered it. So that's where I expect the decision to come down, what Andrew's saying, which is absolutely a judge doesn't have to wait until harm occurs. Now the question is, what are the contours of that gag order?
Glenn, I always wonder during these appeal sessions like this, what trial practitioners like yourself are thinking. I know you've done both, but the trial side of your brain, were you feeling like some of these questions, some of the judges' questions don't really grasp the reality of what we're dealing with?
Oh, I think the judges' questions grasp the reality. And, you always want to be responsive and respectful to a judge without giving up any ground that you don't have to give up. But, I thought there was one observation, I think it was by Judge Millett, when, she was pushing back on Trump's lawyer. Trump's lawyer was taking the position that you really can't limit his speech. And the only limitation is he's not permitted to issue a true threat. In other words, actually commit a crime that would violate 1512, threatening witnesses. And that is the only limitation. And the judge kept pushing back. And Judge Millett said, don't we have a settled principle in the law that someone is inferred to intend the natural and probable consequences of their actions? And I think what she was getting at is that, it doesn't have to be a true threat. For example, on January 6th, when Donald Trump simply said Mike Pence didn't have the courage to do what he should have done, that was not a true threat. But boy, he sure seemed to know what he was saying, and he intended the exact consequences that ensued. His foot soldiers, his supporters, who were sort of mid-attack on the Capitol, instantly started hunting for Mike Pence and began their chants, hang Mike Pence. So really, true threats is not the standard, and the judges acknowledged this sort of call and response, and Donald Trump knows full well what he's doing when he makes the call, and he intends the response.
Glenn, before you go, I have to tell you, I was fully satisfied with just having the audio of this proceeding today. And I actually think in my case, I might have concentrated more because I had absolutely no image distraction in any way. But what did I miss by not actually being in the courtroom sitting beside you?
Well, Lawrence, first of all, you had the benefit of hearing the volume of Judge Millett's voice. Yeah. And I think you would have appreciated her demeanor, serious as a heart attack. She wanted an answer. And the fact that she didn't get one, I don't think that was Donald Trump's lawyer serving him well. But all three judges were very animated and very determined to make sure they got this right. If they're going to support a gag order on a former president of the United States, they want to make sure they get it right. And it was really a pleasure to watch those three judges question not only Donald Trump's lawyer, but the lawyer for Jack Smith's team as well.